This is the current federal tax developments for the week of July 9th, 2018, brought to you by Kaplan Professional Education and your state society of CPAs. This week, we're going to take a look at the states fight back. As the states come, we're going to see a lot of developments this week where the states are dealing with the fallout from the Wafer decision. In essence, the states have been given an opportunity to collect sales tax from out-of-state vendors, and the states now are looking to do just that. We'll talk about those issues. We'll look at what Louisiana, Alabama, Wisconsin, and New Jersey have done in the past week. We'll also talk about the IRS's Large Business International Division, the announcement of 5 new compliance campaigns, and we'll take a look at an email where an IRS agent was wondering if they could assert a preparer penalty against a mere equity holder of a company that was preparing income tax returns and doing so in a way that otherwise would normally trigger a preparer penalty. Well, as we say, it's been a week, and we've now had some time for the fallout from the Wafer decision to come down. And what's happened now is we're going to get a bunch of announcements from states that have begun announcing how they plan to try to start collecting this sales and use tax. So those announcements have now begun to take effect. We had discussed earlier, when we discussed the Wafer case itself, the fact that North Dakota moved almost immediately. In essence, the afternoon that the decision came down, the state of North Dakota updated its website for its revenue department that told us immediately that North Dakota was planning to move on this very quickly. Well, now we're hearing from other states at this issue. One thing to remember about the Wafer decision: states that are members of the Simplified Sales and Use Tax Agreement, that fully implement that, there are 20 of those, and that also will agree to use South Dakota's de minimis numbers, appear to have pretty much a clear path to being able to force outside sellers to collect and remit the sales taxes. We're going to have to see how states are going to react to that. But the fact that South Dakota has the easiest way in for this does not mean that states that do not comply fully with the South Dakota model are ignoring the opportunity here. We're beginning to see a lot more states now come in and start to look at, is there some way that we can take this, we can basically make use of this. So let's go ahead and let's start talking about the first state we're going to look at this week. That is a state that has the most complicated path to getting to the collection of the states that announced this week. That is the state of Louisiana. Now, I have an article we linked to in the PDF for this week and on the website. It is Sales Tax on Internet Purchase in Louisiana coming soon, details on timing and more. It was an article posted on the Advocate of Baton Rouge's website and on July 6th. This particular article deals with how the state of Louisiana is going to try to deal with this. And the article quotes, in this case, the Department of Revenue Secretary Kimberly Robinson, and quotes Kimberly as noting that they are aiming for a January 1st, 2019 effective date for sellers who are selling into the state of Louisiana and have not previously been collecting the taxes and have no physical presence in the state of Louisiana to have to begin to start collecting the sales tax and turn it over. Now, Louisiana is a bit more complicated than most locations. Louisiana is one of the minority of states that effectively allows localities to collect their own sales tax. In fact, generally in Louisiana, one must file a sales tax report with the state of Louisiana and then file separate reports for any cities for which a sales tax may be due. Obviously, it is a far more complicated system. The other hitch is Louisiana is not talking about applying one standard rate across the state. Louisiana wants to make sure that companies charge the proper local rate. So if you're selling to somebody in Baton Rouge, we should get that rate. If we're selling to somebody in New Orleans, we should get that proper rate. So we have to worry about how all of this is going to work. And this is interesting because Louisiana actually had, for catalog sellers, they actually did have a simplified system that was initially designed to allow the catalog seller to pay a flat rate to the state of Louisiana. Well, they've decided that they don't really think they want to go that way this time. They're looking at getting the proper rate. This state's going to be one of the more interesting states to deal with, largely because they're going to have one of the most complicated cases of trying to get their law in place. They have probably, as some commentators said in the articles I read on this week, that Louisiana may be the what we used to call the poster child state for third parties, for outside sellers to challenge under the Commerce Clause using the method that Justice Kennedy suggested, that this system is so complicated and so messy that it imposes an basically unallowable restriction on interstate commerce, that the complexity is just a huge problem. Now, politically, I can tell you that it's going to probably be difficult. It is in most states. If the cities have been used to being able to do their own thing, getting them to agree to a simplified system or getting them to agree to one rate across the state may take a lot of work and may take legislation. It appears Louisiana is going to try to do this without going through the legislative process. And they have a commission set up to study what other states are doing. They certainly are looking at, do they need to come up with some simplified system? What kind of registration, how it would work? And do they need to provide some sort of software? So they're looking at trying to figure out how to basically keep their current system, which has very different rates from city to city, locality to locality, and sometimes very different rules, but may still be able to get the out-of-state money. The next state we're going to look at here is essentially the state of Alabama. And Alabama announced this week, the Alabama Department of Revenue, on their website on July 3rd, they posted a guidance that said, the Alabama Department of Revenue announces sales and use tax guidance for online sellers. Now, Alabama is interesting. Alabama is not a simplified sales and use tax full member state. That is, they don't completely comply with all the requirements to be a full member of the Simplified Sales and Use Tax Agreement. So we don't have all the things. So this is not an SSUTA state. That's a key because obviously South Dakota was a member of the Simplified Sales and Use Tax Agreement, and Justice Kennedy positively commented on that. So what Alabama is going to try to do is not necessarily become a member of the Simplified Sales and Use Tax Agreement. There are parts of that I assume they would not like to have come into their state. And then secondly, it probably would take legislative agreement to get there. So what they're going to do, because they want to start collecting this on October 1st, they're going to go ahead and they'll be using a single 8% rate. If you sell in Alabama, if you're an outside, you have no physical presence in the state, you'll be able to charge a flat 8% rate on sales into Alabama. They have their own simplified sellers use tax program, SSUT, not to be confused with SSUTA. But this system that allows you just to collect 8% is something that a vendor applies for. So hopefully before you sell in Alabama, you have applied for. Once you're approved for that, you can collect just the 8%. You remit that to the state of Alabama, right? We'll be able to make use of that. Alabama also has a de minimis number that is actually higher than South Dakota's. In this case, they have only a measurement based on gross sales, $250,000 or more of gross sales, which is significantly higher than the level that we saw in South Dakota, which was just 100,000. And they don't have a transaction level trigger. Remember, in South Dakota, even if you didn't have 100,000 of sales, if you had more than 200 invoices, 200 transactions, that would force you to have to collect the South Dakota sales tax, even if those invoices theoretically were all for $1. 200 transactions would kick you in. Alabama only has the gross receipts number. Now, this will be interesting because they're trying to design an alternative to becoming a simplified sales and use tax agreement state. I wouldn't be surprised to see somebody challenge this and try to say that you have to be SSUTA. But what I suspect is the courts may very well not say you have to be simplified sales and use tax agreement. But what they may very well say is that you've got to have a program that meets certain simplifications. The question is going to be how much of the SSUTA style structure do you have to accept to do it? Alabama appears to be setting up most, but not all, of the SSUTA benefits. We'll just have to see if that survives court challenge. But again, not unusual. Now, the next state up, let's keep going. Now we're going to talk about the state of Wisconsin. Wisconsin also wants out-of-state sellers to start remitting sales tax as of October 1st. This came up to us two ways. First, the Wisconsin Legislative Fiscal Bureau created a memorandum, which is the memorandum South Dakota versus Wafer Inc., Sales and Use Tax Collections on Remote Sales. That was issued to all members of the legislature, and it was issued on July 2nd. At the same time, various parties, including tax analysts, contacted the governor's office, and the governor's press secretary confirmed that this memorandum suggested numbers that the state would get starting collections on October 1st. So the obvious question was, is that the plan? And the governor's office has confirmed that the state of Wisconsin plans to start requiring these payments on October 1st. So if you have sales into Wisconsin, we have an issue. Now, Wisconsin is a simplified sales and use tax agreement member state. So that's the good news, right? You can come in, all the things you get with simplified sales and use tax agreement, the centralized processing, centralized collection, just using their standard agreement, using their systems to sign up once. All of those things will come with the Wisconsin agreement. But Wisconsin has one other difference. Wisconsin currently has no de minimis numbers in their statute. Now, they have told us, they basically said, and the governor's office has suggested that they're right now studying whether or not they need to have such a de minimis number, and if they do, what that number should be. Wouldn't be surprised to see them go for South Dakota's numbers, but again, no guarantee. This is another potential issue, obviously, here, especially if they try to use de minimis number that is less than South Dakota's, or they go with no de minimis, or even if they try to set one up, somebody could challenge them saying no right to do so. But the bigger question is, if you don't have a de minimis number, now, do you fall under Justice Kennedy's? And we know it's not really a safe harbor, but everybody's reading it as a safe harbor. Do you fall under that rule? That's South Dakota. So Wisconsin, key issue there, though. And one practical issue to remember, most of our clients do not want to become, they don't want to be talked about on this particular podcast in a future session. That is, they don't want to read their name versus, Wisconsin versus them, and to discover whether Wisconsin really has the right to collect this tax. So the practical issue is, I suspect a lot of your clients are going to think that, that we'll let somebody else challenge it. We're going to start initially collecting it. So if you do have a client that sells anything of any significance into Wisconsin, you probably need to start talking to them about whether or not collections may make sense in October. Finally, we have our first legislative issue. New Jersey legislature was still in session. Those of you may remember that the state was being threatened with the government shutdown. So the legislature was still around at the time the case came down. So in Assembly Bill 4261, that was passed by both chambers in the New Jersey legislature, the state of New Jersey has passed a law that was specifically tied to Wafer. In fact, introduced on the day of the Wafer decision. It is still officially awaiting signature of the governor of New Jersey, but it was part of the agreement that kept the government open. So everybody's assuming that the governor is going to sign this thing. So it's not really a question of, is he going to veto this thing? Probably not. The idea is that there's nothing that anybody's aware of that he's against this, unless he found something in reviewing the legislation that would be a big problem. But technically, it's still awaiting signature. Nevertheless, we expect this to become part of the law. New Jersey is and has been a member of the Simplified Sales and Use Tax Agreement. So we didn't need a law change in New Jersey to get that. However, they didn't follow the other things South Dakota did in terms of de minimis. This law, they figure, why push it? They adopted the South Dakota de minimis numbers. Now, as we've noted, some people suggest this might not work for New Jersey because the argument would be New Jersey is a much bigger state than South Dakota. And so, because of this, New Jersey may, in fact, need to have a higher de minimis number. That, in my mind, doesn't stand the test of time as well. I shouldn't say doesn't make as much sense to me. It seems like we're testing here. What is the problem for a single seller? Are we putting too much pressure on the seller? And the answer is, well, if I sell over $100,000 into a state, I don't particularly care if that state is a small state or a large state. Yes, New Jersey will probably impact more sellers simply because it's going to be easier to get 100,000 worth of sales in New Jersey or 200 transactions simply based on population. But yeah, I'm a little concerned that the courts are not going to try to say, oh, some magic number that New Jersey needs that's more than 100 grand, but we're not going to tell you what it is. My guess is they'll probably say the 100 grand, 200 transactions works. That's what New Jersey passed. New Jersey also, the original bill didn't have this, but was added later. They added a marketplace provision. We're seeing this in a number of states. The marketplace provision is, the idea is we want to force entities like Amazon, for Amazon's, marketplace, their sellers. You're aware that 51% of Amazon sales this past year actually came from not Amazon's inventory, but actually were third-party sellers who list their products through Amazon. If you bought from Amazon, you've seen those before, right? You'll see that some things come from Amazon, but a whole bunch of things are coming from some other party. They want to force Amazon to start collecting sales tax. Once Amazon meets the requirements in the state of New Jersey, that will count the marketplace sales. Then they will be mandated to have to assure that all of their vendors are either actually collecting under this rule, or the Amazon or the eBay or the Etsy or whatever we're going to, whatever the entity is, has to assure that they collect the tax on behalf of that party. Okay, we're seeing this happen a lot. Now, this adds a minor complication because if your client is selling via a marketplace, and a lot of small companies do, sell via eBay, sell via Amazon, sell via whatever other company you want to talk about. If they're doing that, then you may want to check the marketplace rule versus their rule. In some cases, the marketplace seller, can collect for them, in which case then they're out of having to register there. The marketplace would take care of it. In some cases, the marketplace is a fallback, but they're still liable. So if the marketplace fouls up and doesn't collect, you have to pay the money in. And in some cases, there's not going to be a marketplace provision. You've just got to step up and collect the tax. So that does add a bit of a complication. Now, this copying South Dakota, the reason it's going to take a while to see these is most legislatures are no longer in session. However, expect next January for us to see a bunch of states start going down this path of let's just copy South Dakota. That's going to be especially true if we have some litigation. Let's say, for instance, we have this New Jersey bill going into law. Wouldn't be surprised to see somebody attempt to challenge New Jersey. And we may very well have the first court decisions on whether the New Jersey law stands up by that time. And if it appears that New Jersey's law is going to pass muster, I wouldn't be surprised to see a whole bunch of states start piling on with similar provisions like this, at least if they can stomach being part of the simplified sales and use tax agreement. Some states will, some states won't. In any event, it's a bit of a mess. So let's remind ourselves, where do we stand now working with clients? I'm hearing lots of questions on this. We need to worry with our clients again. Your clients need to figure out where they are selling. You need to tell your clients that gig's up now. It's very clear that states do not have to, that you cannot get out of collection by the saying that the state, that I don't sell, or I don't have any assets in that state. I don't have any property in that state. You're not going to be able to get out of that. The court's made that fairly clear. Yes, we're seeing cases in Virginia where Virginia has a law that's trying to stop this by trying to burden the outside state. We have the same issue being proposed in New Hampshire. My gut tells me those things are probably not going to withstand this. The Supreme Court was pretty clear in this case. And so I have a feeling those will be problematical. So your client needs to wonder, which states do I need to worry about? Again, list of sales by state, and then a list of how many transactions are in each state. So transactions per state, sales per state. I would certainly flag anybody who's over either $100,000 or 200 transactions in a state. The South Dakota, Justice Kennedy quasi-safe harbor number. And then I would be very concerned, especially if those states are simplified sales and use tax states, because you've got to assume those states will come into line. You want to make sure your client checks with those organizations, checks with those states that they're selling into to see when the trigger is going to come. You probably also, and I know we're not going to like it too much, but a lot of your clients are going to come to you asking how they can comply with this. Like it or not, I think most of us got to get up to speed on the various alternative software systems that are available to comply with sales and use tax. Things like the Avalara systems or those from TaxJar, there are various other products out there, how those interact, how those work with your clients. By the way, interesting thing was pointed out to me on the Tax Pros subreddit was, and I hadn't noticed this either, but look back, yeah, it's true. Avalara had the best timing ever. They went public just before this case came down. So Avalara, who's probably the best known of the software vendors who will help you handle sales and use tax, yeah, they went public at the right time, I think. I think this is probably a good time to take your company public if you're Avalara. Next up, let's talk about some federal issues here. Now, the IRS, the Large Business and International Division of the IRS, has announced 5 different compliance campaigns. Okay, these compliance campaigns are meant to, check to see about problems that may be existing in various areas. So these are areas that we could expect the IRS is going to look at in the future and concentrate on. So it's useful to know that these are what the IRS consider to be problems. They expect compliance issues here. And obviously, backdoor, that means they expect some money when they go in and take a look at these issues. There are 5 areas. Let's talk about what those 5 are. The first thing is they're going to have a look at the restoration of the sequestered AMT credit carry forward. You may remember that we had a sequestered AMT credit carry forward. We then have that gets restored when the budget numbers work. That's a total mess. I think they just kind of assume that, yeah, people may have gotten that wrong. We're going to take a look. Now, this one's interesting for smaller entities. They're going to take a look at S corporation distributions, right? They want to know if we're properly reporting for our S corporations the tax effect of our distributions. And that, ladies and gentlemen, may be a very interesting thing to try to follow. Because obviously, most studies have looked at this, have determined that it's unlikely that most taxpayers, a lot of S corporation taxpayers are not properly reporting the tax effects of their distributions. They want to look at when the S corporation fails to report gain upon distribution of appreciated property to a shareholder. Remember, unlike a partnership in an S corporation, you distribute appreciated property to a shareholder. The corporation has to recognize the gain. They want to say the second issue is when an S corporation fails to determine distribution, whether in cash or property, is properly taxable as a dividend. Did you go in excess of AAA? And if you did, does your S corp have earnings and profits? Can you document that? Do you have that information together? And finally is when a shareholder fails to report non-dividend distributions in excess of their stock basis. That's the idea of having your basis calculations for the S corporation and how the shareholders are doing that. The third area they're looking at is virtual currencies. Again, they're looking at, are people complying with Notice 2014-21 about how we tax these currencies, right? They also want some guidance about how this is going to work, where this is coming, how those issues. They are urging taxpayers, if you have not reported your virtual currency transactions, you probably should report them as soon as practical, and says the IRS is not contemplating a voluntary disclosure program to specifically address non-compliance involving virtual currencies. Some parties have suggested the IRS should do that. The IRS now is telling us in this document, we don't plan to. We also look at foreign triangular reorganizations. And you can read on that. That's not going to affect probably most of you. But if you have that, yeah, I need to worry about it. Also, not surprisingly, the 965 transition tax. How are people handling that, and are they doing it appropriately? These 5 areas the service plans to be concentrating on now. So that raises a whole bunch of interesting areas. Again, if your clients have exposure in these areas, probably is best for you to go ahead and tell the clients that, we may want to try to get this taken care of. Certainly look at how your clients are handling these issues. Finally, let's talk about a Chief Counsel email. This is a Chief Counsel email 2018-25028, was issued on June the 21st. This is a question of when can we assert a penalty, a preparer penalty against someone who's an equity holder of a preparation company. In this case, they were looking at the nasty penalty under 6694. This is B, when there has been willful or reckless conduct. In essence, been ignoring the tax law willfully. So the IRS has this situation now where the agent believes there has been willful misconduct. Now, the agent in this case wants to not only go against whoever the individual preparer was. Let's say it was somebody in the office, in an office, one office of the preparation company who did this. Now they want to know, can we go after the equity holders? Because you know what? Maybe that individual preparer is, really doesn't have any assets. Maybe the company doesn't really have assets. But what about these shareholders? Don't they have some liability to pay this penalty merely by owning an interest in this preparation service that had a preparer who willfully disregarded the rules and ends up with the willful understatement penalty against the preparer? Well, this is an email in response to a question of whether they could assess against that person. The email notes that normally this penalty at 6694 applies only against the individual preparer. So let's say I'm a preparer with a firm that has 300 preparers. If I do something, I sign off on a return where I have willfully ignored the law, I have personal liability, and there's no question that's true. It also notes that only under unusual circumstances where basically there's been a broad, kind of intentional ignorance of the issue, the people in charge have been ignoring the problem. There are cases where we can stretch that to go up to and say, you know what, not just this preparer owes a penalty, but also the preparing organization as a whole does. And they said, well, that's true. And if you have those facts, we can go to the organization. Can we also go, though, which is our key question, can we also go to the owner? Well, here's where this came down. In this case, they said, well, there is a case called United States versus Elsis, which is a Southern District of Ohio case in 2013 that was affirmed on appeal by the Sixth Circuit, where they did assess a penalty against Elsas. He was the owner of the entity. But the court says, but the memo says, but that's got a very important set of facts. Elsas was also a preparer, prepared most of the return. 28 of the tax returns at issues were prepared by him. And the owner of the entity were the moving force behind decisions and calculations. And because of that, they said in that particular case, they go against the equity holder. But they did note that as a general rule, the 6694 penalty does not go out to an owner unless you can clear the hurdles that we saw in the Eslis case. The memo makes pretty clear, the email response makes pretty clear that that's not going to be the normal situation. Well, another week's gone by, and as we say, it is summer and time to take a look at your courses for the year. Make sure you check your state society catalogs for courses that are coming up. I'm going to be in New Mexico on Monday, doing some sessions and doing a session in Albuquerque. And then later in the month, I'm going off to New Jersey to do another set of sessions there. This time, I'm going to be talking about estate taxes. Also, looks like we'll be trying to do a session
that will deal with Quicken and some of the security on computer systems. That's also scheduled. One session, I believe the one on Quicken is scheduled in Iceland, the one in Iceland, New Jersey. The one on the estates is scheduled to be at the New Jersey Society offices in Roseland. I'll also be on August 3rd. I'm going to be doing a webcast for the Iowa Society. That's going to be an interesting 4-hour webcast. It's farming and ranching businesses in the Tax Cuts and Jobs Act. Kind of an interesting view. Obviously, we're going to talk about some things that, with an aim toward what of these things would hit a farming or ranching business. Most of that's going to be things that hit all businesses because, there's not a whole lot there. We will talk a little bit about the grain glitch, which actually was a big thing and now becomes not so big a thing. So I have a brief discussion about how they fix the grain glitch and what that does. So that has some impact, assuming that you have interest in cooperatives, but otherwise not a big deal. That the broadcast will start at 9 a.m. Mountain Daylight Time on August 3rd, 8 a.m. Pacific Daylight Time, because there are parts of the state of Idaho that are in a Pacific time zone, parts are in mountain, so you got to swap those 2 dates. If you want to register for this, the Idaho Society website has it at idcpa.org, so you can find information about registering for the course. Again, August 3rd, one more time, talking about the Tax Cuts and Jobs Act, this time geared somewhat toward looking to how it impacts farming and ranching businesses. As always, this has been the current developments for this week. Be sure to catch our regular updates on our website, currentfederaltaxdevelopments.com. You can also send questions or comments to me. My email address, edzollers@currentfederaltaxdevelopments.com. You can follow me on Twitter. There you'll find me at edzollers. And I also follow discussions on the subreddit on reddit.com, which is /r/taxpros. So you want to go there, you can see it. Otherwise, hopefully you're having good fun this week. I know here in Phoenix, it got hot. Most of the country, it appears, it got really hot this week. So hopefully you're keeping cool. And we'll take a look next week about what is continuing to happen in all these nice areas. We're still looking for those regulations on 199 Cap A to come out. Remember, we thought we'd get them by the end of June. Well, end of June has passed. We're still waiting. We're looking for other regulations on the Tax Cuts and Jobs Act that we hope will be released soon. And I wouldn't be surprised to see a few more Wafer announcements come from the various states. So, keep by your computer, I should say, or your iPod, your iPhone, whatever you're listening to this on. And we'll go over next week what we expect, what the changes have been and what issues have arisen in the area of taxes.